So our next topic is about legal issues in sourcing. Well, there's a lot of legal issues that are out there, and we're not going to cover all of them, but we're going to cover, for example, laws of agency. So this is where you have agents and principals. So an agent is the one that's actually doing the sales and the purchase manager. But they're doing it on behalf of the principal, which is the company. So the company has designated certain people, whether by job title, position description, or by doing it in writing. Like, for example, the federal government uses a warrant. It's a purchasing warrant that gives that person authority to purchase on behalf of the principal, which would be the federal government. So I had one of these when I worked for the federal government. However, I don't work for the federal government anymore, so I don't have it anymore. But I was a purchasing agent for the federal government. So I was the purchasing manager in this example here. And I worked on behalf of the federal government. And so I would talk to sales representatives who were the agents for the supplier company. And I would negotiate with them. You know, they wanted to sell it for $100,000. I'm like, no, I don't want to spend that much. How does $70,000 sound? And then we would go back and forth. And then it would be, we'd come up with a number. And depending on the dollar amount, my warrant was only good up to a certain dollar amount. If it was under that, I could approve it. If it was above that, I had to get somebody else who had more authority to approve that purchase. But you have to remember this. Unless you are the CEO or, the owner of the company, you are not the principal. You are an agent of the company. So remember this, because this is going to go into the contract law. Because sometimes in contracts they define who's the agents and what their authority is under the contract. So here's some common elements that you'll see in contracts. So you'll see the offer. So it's the expression of intent to do business. Then you have acceptance of the offer. So meeting of the minds, an agreement, mutual assent. Consideration, something of value is exchanged. Most commonly, this is money that is exchanged for goods. However, it doesn't have to be. It just has to be something of value. For example, if a company is going to move, they may offer their building as an exchange for a new building, plus some money, let's say. So that way it's equal consideration, or whatever the agreed upon consideration is. So this is just an example. It's just something of value. However, most commonly you'll see it's a dollar amount. And then the contractual authority of the parties. This is where the agents and the principals come in. So the parties must be authorized to conduct this business. For example, you yourself might be trying to enter into a contract, but are you, as an individual, authorized to conduct business on behalf of your parents? Now, some of you might, using a document such as a power of attorney. Some of you, and I would say most of you, are not authorized to conduct business on behalf of your parents. You are not an agent of your parents. Well, you could also consider it, are you an agent of Starbucks? I would say probably all of you are not. I don't know your backgrounds or your current occupation, so I'm going to go out on a limb there and say that you're not. So this is where that authority comes in for the principals and the agents. And then we have our legal subject matter. So we have to make sure that what we're doing is legal. Because if it's something illegal, then a court is not going to enforce that aspect of the contract. Now, what's legal and what's not legal may vary from area to area. What might be legal in Illinois may not be legal in West Virginia, which may not be legal in Pittsburgh, let's say. It can go down to the city level, what's legal and what's not legal. So this is something you also have to know in case you are doing international contracts. So if you're doing a contract with the United Kingdom, a company in the United Kingdom, there might be something that is illegal according to their laws. So you cannot enforce your contract in the United Kingdom courts because they'll just look at it and say, you can't do this, and they'll throw you out of the courtroom. And vice versa. There might be something that's illegal in the United States that's not legal in the United Kingdom. So this is where lawyers earn their money. And none of us are professionals when it comes to legal matters, so involve the lawyers. So what happens when contracts don't go as planned? You know, somebody is not performing to their level as specified in that contract. Well, we have to consider canceling the contract. This is one of the last things we want to do, but it's something we have to consider. So when one party is not performing to their contract, it could be considered that they defaulted on the contract. They failed to do something in the contract. This is known as cancellation for default. For example, you are renting an apartment, you do not pay the monthly rent, they could cancel your lease agreements or your rental contract under the grounds that you defaulted. And then you'd have to leave. If you chose not to leave, they go to court and they throw you out. You know, they'll bring the sheriff or the bailiff and you will be escorted out of the property. Hopefully none of you have to go through that. But this is cancellation for default. One party or both failed to do something. Now there's also this other aspect. No one's really failed, but it's just more convenient to cancel the contract. Both parties have to agree to cancel for convenience. And usually this is specified in the contract. All of these things are specified in the contract. Now, canceling for convenience might mean canceling one aspect of the contract. For example, if you no longer need a certain product that's on the contract or the service that's on a contract, you may, under the terms of the contract, be able to cancel that aspect, leaving the rest of the contract in place. So this is where the wording of the contract is very important. And then we have the last one here. Let's say you had a default. You can't resolve it with just by talking to the company. You know, talking to the other side, the other party in the contract, or the multiple parties in the contract. It can be between multiple parties. Well, everybody can agree just to cancel the contract. Make sure to get it in writing, but everybody can agree that, hey, this isn't just working out. Let's cancel this. Let's draw up the paperwork to cancel this properly and legally and be done with it. So these are 3 different options to cancel a contract. And like I said, talk to a lawyer. Talk to your company's general counsel. If you are the business owner, talk to your lawyer. If you don't have a lawyer, go find one. Most lawyers will talk to you for 15 minutes to 30 minutes for free, just to understand what's going on. And they may offer a little bit of advice, but they'll also say, well, I can do more if you pay me. So definitely speak with a lawyer on this. If it's not you, your boss's boss, an executive, whatever the case may be, somebody needs to talk to the legal office, your legal department, to make sure everything is done correctly, because it can bite your company in the butt. So there's also more legislation, at least in the United States, and there's other initiatives that impact our sourcing practices here in the United States. We have the Uniform Commercial Code. And this is about trade between the states. Now, interstate commerce is a federal level thing. So that's why we have a uniform, meaning it applies to everybody equally, commercial, because we're not talking about personal here, code. Sometimes in contracts you'll agree and sign a UCC form, might be UCC 1, 2, 3, whatever the number is, a form basically defining it that can be actually filed with a court. So definitely understand the Uniform Commercial Code, because it defines a lot of things here. And it might be saying, okay, well, because the buyer is in Texas and the seller is in Nebraska, well, the buyer has the ability to go to court in their geographic area. It might be something like that. It might define where you have to go to court, if you have to go to court. So we have the Sarbanes-Oxley Act. You'll usually see it as SOX. And this primarily goes for publicly traded companies. So there's transparency in the financial statements, business processes, and procedures. Transparency when it comes to business processes and procedures doesn't mean that it's word for word out there. But if you think about it, as a shareholder of that company, you are a part owner of that company. And that means you should have access to financial statements. And the business processes and procedures are usually defined and included in the annual financial statement or annual report of the company. Sometimes you'll see it as an annual report to shareholders. If you just look up something like that, put the company name, for example, Twitter, annual statement to shareholders, you'll find it. These are not private documents. If they're a publicly traded company, they're required to file these. And then we have the Dodd-Frank Act. So this promotes more transparency, reporting, and disclosure. So it's essentially just adding more requirements onto the Sarbanes-Oxley Act. And there's some other key things in there. Your text will further define this, but just see it as it's going further than the Sarbanes-Oxley Act did. All right, so now let's start looking at international here. So we have Customs Trade Partnership Against Terrorism. So if you're importing stuff into the United States, this is a initiative and legislation that will impact your imports. Sometimes this delays your imports, but basically you have to report everything that's being imported. Now, it might not be your company, it might be the exporter from the foreign country that reports it to customs, but ultimately you're responsible as the importer to let customs know what's coming in. And then if they choose to inspect that cargo container, you want to make sure your inventory is accurate, because that's how our supply chain security is improving, because customs now knows exactly what's coming into the country. And I believe after 3 imports, you can qualify and apply for a trusted importer designation for your company. So, which kind of smooths things out a little bit, makes it a little easier, but still you have to go through this process. And I believe the cost for importing, or at least the customs side of it, is a little cheaper. But don't hold me to that, I'm not 100% of that. But then finally we have our Foreign Corruption Practices Act. Well, I mean, you see it all the time in movies. When they display a foreign location, a person brings in a suitcase full of money, or they receive a briefcase full of money, or jewels, or diamonds, or whatever the case may be. Well, there's laws in the United States where this is illegal, regardless if you're doing it overseas in a foreign country or within the United States. And you are not allowed to accept bribes or payments. The payments may not be a bribe. They might say, oh, this is a payment because you're having a birthday. Or this is a gift because you're having a birthday. But the real intention is to influence you maybe to use that supplier. Or, various things. So your company most likely has some type of gift policy Most of the time you'll see it as a gift policy, which includes payments and bribes to foreign companies or receiving it from foreign companies. For example, when I worked for the federal government, my dollar threshold was $25. I could receive a gift and keep it if it was $25 or less. However, I could not accept a lunch or food or anything like that. I'd have to pay for myself. The gift could be that someone else just picks up the check. So, I believe also if it was under $500, I had to report it, and somebody up higher up the chain would say if I got to keep that gift. And then if it was over $500, I had to turn it in to the location's purchasing office, for that way they can keep the integrity. And then the gift was recorded, who it was. If legal action needed to be taken, it was handled by the law office or the legal department, and that gift was usually donated to charity. That way, the company could, the federal government kept their hands clean on the gift by donating it to charity. They had a paperwork process saying what happened to it, and everything was good. So learn what your company has for a policy, and if you have any questions at all, ask your manager, your supervisor. Make sure to understand that process. Now, it's most likely you will never experience something like this, but it's possible. So go ahead and make sure you understand it completely. So that's it for this section of topic 4, where we're talking about basically about contracts and the different legislation that's involved with it. But next we're going to look at ethical sourcing. So let's go ahead and move on to ethical sourcing in our next video.